everybody. Welcome to the session, SLAPPs and Anti-SLAPP Remedies, What You Need to Know. My name is Jonathan Peters. I'm the moderator today. I'm an Ohio lawyer and a professor of media law at the University of Kansas, of all places. Random and odd, but that's where I am now. So I'm going to give you a brief introduction to SLAPPs and Anti-SLAPP Remedies, and then for the most part, I'm going to get out of the way and let the expert panelists take over. So I'll just go through a couple of, I'll introduce you here to a couple of individuals and then introduce you to the four corners of what a SLAPP is and what an anti-SLAPP remedy looks like. So James and Lisa Cioscia were political activists. Michael Stark, a contributor to the Huffington Post. Ken Ward, a reporter for the Charleston Gazette. Margaret Newkirk, a former reporter for the Akron Beacon Journal. What do they have in common? They have in common Robert Murray, who is the founder and president of Murray Energy, the largest privately held coal company in the United States, whose operations dot the Ohio River Valley and are headquartered in Pepper Pike, Ohio. At different times, he has accused them all of making defamatory statements about him or about his company. They're not the only ones. In the last 15 years, Murray or his company have also sued a team of journalists at the Chagrin Valley Times and threatened to sue Steve Fisker, editor of Coal Age and Engineering and Mining Journal, and R. Larry Grayson, a professor emeritus of energy and mineral engineering at Penn State University. So far, none of the cases or threats has produced a judgment on the merits for Murray. Instead, they've settled or the defendants have prevailed on pretrial motions. Murray has every right to defend his reputation against real claims of harm, using the law to redress them. But the company is a major player in local economies. Murray himself is a major player in state and local politics. And their record, both Murray and his company's record, of suing journalists and activists or threatening to sue them, whatever their motivations may be, with the intent or effect of suppressing constitutionally protected speech, stands to chill expression on important business and industry practices. That's problematic because speech and assembly activities on matters of public concern are essential to effective governance, to the resolution of broad social problems, and to responsible resource management. First Amendment values and the principles of pluralism demand that citizens have the opportunity to speak and protest peaceably, free from threats of litigation by individuals or organizations whose resources are superior. In some of the suits filed or threatened by Murray, he has looked the part of an oppressor, using the law and his superior resources to discomfit people who criticize him or his companies. And whether or not Murray is actually intending to play that part, the effects of those activities are evident. A panel, this was in 2014, of the Ohio 8th Appellate District, this was in affirming a summary judgment against Murray in one of the SLAPPs that he filed, concluded that, quote, "This case illustrates the need for Ohio to join the majority of states in this country that have enacted statutes that provide for quick relief from suits aimed at chilling protected speech." And then the panel went on to say, and again I'm quoting from the court, "SLAPPs can be devastating to individual defendants or small news organizations and act to chill criticism and debate. The fact that the Chagrin Valley Times website has been scrubbed of all mention of Murray is an example of the chilling effect that this has. Ohio should adopt an anti-SLAPP statute to discourage punitive litigation designed to chill constitutionally protected speech." So generally speaking, a SLAPP, which stands for Strategic Lawsuit Against Public Participation, is a civil complaint filed against someone for his or her expressive activities. So it could be petitioning, could be assembly, could be speech or press, on a matter of public concern. And SLAPPs come in a number of different forms. They also come in, they rise under different legal theories. So some of them are defamation suits, others are privacy suits, abuse of process suits, and 28 states so far have passed an anti-SLAPP statute. But as the 8th Appellate District pointed out, Ohio is not one of them. So against that backdrop, we're going to talk about SLAPPs in general, how tough it can be to defend against a SLAPP in Ohio, and Ohio's legislative and judicial efforts to create anti-SLAPP remedies. Leading that discussion, we've got a great lineup of experts in SLAPPs here, and I'll just start here from the left with Dennis Hetzel. He's the executive director of the Ohio Newspaper Association, where he oversees its operations and those of the Ohio Newspapers Foundation. Before joining ONA, he worked as a sports editor, a news reporter, a movie critic, an editorial writer, an editor, publisher, and website manager. Down from him, we've got Jeff Nye. He's an associate at Stagnaro, Saba, and Patterson in Cincinnati, where he specializes in commercial litigation and performs significant pro bono work in First Amendment law. Before joining the firm, he clerked for Judge Beth Myers, the Hamilton County Court of Common Pleas, and helped implement Ohio's commercial docket program. And then all the way at the right, we've got Jocelyn Rosnick, who is the Assistant Policy Director for the ACLU of Ohio, where she develops and executes policy campaigns and coordinates policy and legislative programming and events. Before that, she was Development Manager for the Ohio ACLU, in charge of donor research and outreach, as well as foundation and grant support. And I'm actually on the board of directors for the ACLU of Ohio, so Jocelyn is awesome. She's terrific. All right, so with that being said, I'm going to jump out of the way and let the actually smart people talk.
Thanks, John. Hi, everyone. Can you hear me okay? Okay, wonderful. Out of my own curiosity, can you do me a favor and raise your hand if you're a lawyer? Okay, raise your hand if you're a journalist or you work with the media, and if you're a student. Okay, so it's a really mixed bag. So my job today is to really lay the groundwork for a conversation on SLAPP suits and anti-SLAPP remedies and what you need to know. So I'm going to give the back to basics overview. I want to start by making a point that the right to speak your mind and to fight for what you believe in is really one of our nation's oldest and dearest principles. But for just as long, there have been constant forces that would prefer it if critics and certain individuals and organizations would simply stay silent. And those same forces are often willing to expend an incredible amount of resources making sure that that is the case. So I'm going to talk about SLAPP suits in general and what they are. John mentioned that SLAPP stands for a strategic lawsuit against public participation, and that term actually hasn't been around all that long. Maybe 30 years or so. It was coined by a few professors, but I do want to note that this type of lawsuit, this type of litigation, has actually been around for much, much longer, and some of the original SLAPP cases actually go back to your right to petition the government. So basically what a SLAPP suit is a civil complaint or a counterclaim against a person or entity that is speaking out on a public matter, something of public importance and concern. Not just anything that you're speaking out on, it really has to be something that grabs the public attention. The interesting thing about SLAPP suits is that they are disguised as ordinary civil complaints and litigation tactics. Most commonly, this is something like defamation, false light, invasion of privacy, interference with contract or economic opportunity. More often than not, the people or entities that are filing these SLAPP suits are coupling a number of claims together. You'll see, 2 to 4 of them at a time. And most often, when we think of a SLAPP suit, we're really thinking of a defamation lawsuit. So someone alleging that you've made a false statement of fact that's going to injure or harm the plaintiff's reputation. This could be written, which is libel, or spoken, which is slander. So who is filing these lawsuits? Number one, it's businesses, and I'm not talking about mom and pop shops down the street. Could be, but more often than not, it's going to be a much larger business or mega million or billion-dollar corporation. It's also going to be elected officials or certain government bodies. And who is getting hit by these lawsuits, or who is actually getting slapped, are generally everyday people like you and me. Usually, it's not individuals with a vast array of resources, time and money. It's an everyday person. Additionally, journalists and media outlets get hit with SLAPP suits fairly often as well. So I wanted to put up a little by the numbers on the slide for you to show you types of action that actually results in SLAPP suits being filed. And you will start to notice something here, that all of this is really protected activity. These are very common things for people to do. Participating in a legal protest or boycott, writing a letter to the editor, speaking out at a community meeting or at a city council meeting. Maybe you're a journalist, you're writing an article. These are all things that have landed people subject to a SLAPP suit. And that leads me to my next point. SLAPP suits are highly problematic for a number of reasons. Really, the goal here is to chill speech and to negatively impact public participation. And I would argue that when our society and when our democracy is working best, it's when we actually have a lot of public participation in speech. It's more, not less. That's something you're probably going to hear all throughout the day in various panels, that we want more speech, not less speech. But these SLAPP suits really are designed to intimidate the target and to discourage the target and others from continuing that speech, to speak out on an issue of public concern, some public matter. So really it is to choke the free speech of that person or entity and to silence the critics. And the biggest problem is that it turns our court system into a war of attrition, a place where who's actually right and who's wrong doesn't matter nearly as much as who has the most resources, be it time or money. Additionally, I want to make another even more practical argument that these SLAPP suits are really meritless legal claims, and they end up clogging our already overburdened court system. So before going over a couple example SLAPP suits, I want to talk quickly about the sister to the standard SLAPP suit. This is a cyber SLAPP. Just from the title of this, as you can imagine, this is really a SLAPP suit where the speech originated online. So this is something like writing a blog, leaving a comment on a website, leaving a review on a place like Yelp or Angie's List. These are things that typically everyday people do fairly often. I know that when I go get a service provided, I tend to be a reviewer. I leave those, 3-4 star reviews and add my comments. Unfortunately, these actions have landed individuals subject to cyber SLAPPs. Now, much like a standard SLAPP suit, the underlying claims are generally meritless. The goal is really not to achieve a favorable outcome in the courts. Oftentimes the people filing these cases don't actually think that they're going to win, but it's really to chill that speech. And in a cyber SLAPP, there can actually be an additional very insidious goal, and that is to reveal the identity of an anonymous critic. So oftentimes when you're leaving a comment online or leaving a review, you can have a fake username. You can actually leave it just anonymously in general, where there is no cover name for you. And oftentimes when the cyber SLAPP is filed, it will try to reveal the identity of that anonymous critic through a subpoena to the website or the internet service provider. And unfortunately, in the era of technology, these types of cases, these issues are coming up more and more. Just a couple of years ago, the ACLU of Ohio actually had to step in on one of these to protect the anonymity of commenters on a blog. And my co-panelist, Jeffrey Nye, actually was one of the lead counsel representing the blogger in that case. So now I am quickly going to go over 2 examples so you can really see what a SLAPP is like in real life. So the first is a sample cyber SLAPP, and this is Dietz Development versus Jane Perez. Now, Ms. Perez had been living in her home for a while, and she decided that she needed to have some remodeling work done, something that many of us will probably do at one point in our lives. And she consulted with a variety of different development firms and decided to go with Dietz Development. Unfortunately, from the get-go, there were disagreements, and the disagreements led to unpaid invoices. And the unpaid invoices eventually led to Dietz Development filing a lawsuit for full payment from Ms. Perez. There were errors in the lawsuit, and it actually ended up getting thrown out on procedural grounds. But at the end, no one was happy. Dietz Development wasn't happy, and Ms. Perez was not happy. Ms. Perez decided to voice her concerns online by leaving reviews on Yelp, Angie's List, and a few other review sites. She stated that there was damage done to her home, that the job was incomplete, and she also talked about lost jewelry that went missing during the time that Dietz Development was working on the remodeling project. As you might imagine, Dietz Development was not pleased to see these negative reviews spiraling out there on the internet and chose to respond by filing a defamation lawsuit. Not only did they file this lawsuit, but they sought extreme damages. They sought $750,000. Now, I'm not a gambler, but I would bet that Ms. Perez didn't have $750,000 just laying around. I know I don't. Many of you probably don't either. So this was a very strong intimidation tactic on the part of Dietz Development. It really was to show force and to try to get Ms. Perez to stop speaking out about her negative experience with the company. Now, the judge did end up ruling on an early motion and did stop Ms. Perez from continuing to mention the lost jewelry. Eventually, this case went to a jury trial that lasted 5 days, and no damages were awarded. So it really was a baseless case that took up a lot of time in the courts. It also took up a lot of time and resources. Jury trials are time-consuming and expensive. So the damage was done. The company made the point that if you leave critical reviews about them on sites like Yelp and Angie's List, that they were going to file a lawsuit against you. And lastly, I want to quickly touch on one of the cases that John mentioned related to Robert Murray. A number of years ago, there were actually 3 somewhat related SLAPP suits filed by Mr. Murray, and I'm specifically going to quickly go over Murray v. the Huffington Post. So in this case, Mr. Michael Stark was a journalist for the Huffington Post, and he wrote an article titled, "Meet the Extremist Coal Baron Bankrolling Ken Cuccinelli's Campaign." The article was highly critical of Robert Murray and the company, the Murray Energy Corporation. Within the article, Mr. Stark called Murray an extremist billionaire who fires his workforce wholesale and fits a fight when electoral results disappoint him. It also stated that he laid off over 100 employees, making good on a promise to fire employees if Obama won re-election. So as you can see, this was really a critical article about Murray and Murray Energy Corporation. Mr. Murray is no stranger to filing lawsuits, especially SLAPP suits, and filed a SLAPP alleging defamation, false light, and invasion of privacy against Mr. Stark and the Huffington Post. In this case, the ACLU stepped in to represent not the Huffington Post, they already had separate counsel, but Mr. Stark, the journalist himself. And we filed a motion to dismiss, and we were actually successful somewhat early on in this case, which is rare for a SLAPP suit, but it was not an easy battle. But the judge did side with us, and the case was dismissed because Mr. Stark was protected by the First Amendment, but he was also just voicing his own opinion, so it did not meet the legal standards of defamation. And for whatever reason, Mr. Murray chose not to appeal that specific SLAPP suit that he had going on at that time. And with that, I will turn it over to my other co-panelists.
Just a quick question. Where was that suit filed?
It was the U.S. District Court of Southern Ohio with Judge Frost.
It was filed in Belmont County.
And then it was moved,
to
yeah, yeah.
District.
I'll have the clicker. So it's first at the top one?
Just the arrow on the side.
There we go.
Yep.
I'm going to talk a little bit about what we're trying to do and how we're hoping to do it in Ohio, and then turn it over to Jeffrey to talk about some of the details of what's in our draft bill and some of his experiences, which are really pretty remarkable. The first thing you may notice is we have a nice, clever name for what we are trying to accomplish called the Ohio Citizen Participation Act. This is modeled is after what Texas and some other states have done. And early on, when we actually were talking to the state senator, Senator Eklund, some months ago about this and talking to him about it. His district includes Chagrin Falls, which is our member newspaper that got in the middle of this Murray Energy litigation. And he said, you know, anti-SLAPP doesn't mean anything to most people, and it's kind of a negative thing, which the word anti would imply, of course. You need to come up with something more positive. And I said, that's probably a good point. And I think Ohio Citizen Participation Act kind of says it. You know, and on this first slide, you see the quote from the pretty remarkable appellate court decision in the Murray case that Jonathan read earlier about, you know, Ohio needing an anti-SLAPP law. And so, you know, it's really important not just to have any sort of anti-SLAPP law. You know, we want one, you know, that is hang on. That's not good. So I'll just keep talking while we figure out what just glitched. You want one that's broad and not narrow. Some of the states that have narrower laws, they're not as effective. And one of the most important things, which we'll talk about more in a minute, is having expansive definitions of you know, matters of public interest and what is protected communication, so that it covers business situations, cyber issues, as well as, you know, the more classic anti-SLAPP example where, you know, I'm at the town board meeting and the township meeting, and I complain about the developer's plans, and the developer sues me, you know, and those situations happen. They happen in Ohio, but there's a lot more to it than that. So we've been in the process over the last some months of about a year of coalition building here in Ohio. And you know, our interest at ONA started, quite frankly, with Ken Douthit, my publisher of the Chagrin Falls newspaper, and I can't remember the number, but it's an astounding amount of money that Ken and his insurance company had to spend to contest the litigation against his newspaper, both not for their article, their editorial, and their editorial cartoon. And I just want to point out, to reinforce the point that when we're talking about anti-SLAPP laws, we're not talking about expanding protection for libel and slander. We met with Representative Cupp, former Supreme Court Justice Cupp, recently to talk to him about our plans, in hopes, obviously, that he may support us when there's a bill to look at. And he asked that question. It's a very good question. What you're talking about in anti-SLAPP is, you know, you're still, you know, accountable, certainly if you're a publisher or anyone else, for libel or slander. What we're talking about is protected speech, and there's settled law on what is protected speech. And it's an expedited process to, you know, to free you of the burden of long, expensive litigation that you would very, very likely win anyway if you have the deep pockets to fight it out versus settling or conceding. So I just think that's an important point to make. One of the interesting things about building a coalition for an anti-SLAPP law, I'm on a listserv with a bunch of lawyers and others from around the country that have been, you know, heavily involved in some of this stuff. You know, there's the saying about politics making strange bedfellows, and anti-SLAPP laws make strange bedfellows, people that wouldn't normally be in the same room. And what's good about that is there's an opportunity here for bipartisan effort. We've been working with Senator Kenny Yuko, a Democrat from Northeast Ohio. He has some constituents that were in the middle of this Murray Energy situation, which is what brought, you know, his interest in. But we really are hoping to find some Republican support because, you know, the simple reality of the Ohio politics right now is the Republicans are running everything. So, you know, we can feel good about having a Democrat introduce a bill we like and watch it not do anything, or we can, you know, work with both sides and you know, get some Republican support and actually accomplish something. And this may, you know, I'm not sure if the draft bill, which we'll talk about more in a minute, will get introduced this fall. I think it's very unlikely even if it got introduced that I can't even imagine it passing with all they're going to have to deal with in lame duck, including mischief we probably can't predict yet. But I'm a little worried about a couple open meetings things, but that's another panel. But it'll start the conversation, and I'm sure we'll get something introduced in the next General Assembly, and maybe we can get this done in the next 2-year cycle. It'll probably be a lift of a year or two, if not more, to get this done. But that's okay. So who's in our coalition? Some of the ones you wouldn't be surprised to see: the ONA, the Broadcasters, Common Cause, the ACLU. The Motion Picture Association of America. Why would they care? The MPAA has been active in these bills all across the country, particularly to protect documentary filmmakers. In the area of documentary filmmaking, excuse me just a second, I'm fighting a cold, you may be able to tell. A lot of documentary filmmaking takes a very, an advocacy point of view, which, is a long tradition in America, going back to Common Sense and the arguments over the Federalist Papers. So they've been active in this. Yelp, we talked a little bit about that already. Someone posts a review. I didn't like, the chicken I had at Bob's Chicken Shack. It was really greasy, and I got sick the next night. Well, Bob sues, to, unmask me. And one of the unique provisions, I think we'd be the first one in the country to do this, in our draft bill, also deals explicitly with protection of anonymous digital speech. And to unmask me and again sue me. And again, this is my opinion. This is protected speech. We're not expanding, the definition of libel and slander. It's protected speech. So Yelp has taken an interest in what we're doing in Ohio, as they have in many other states. A lot of attorneys, such as Jeffrey, are part of our group, have been involved in this litigation. The 1851 Center for Constitutional Law, which is a conservative group, that's involved in preserving constitutional rights, strict construction, et cetera, et cetera. They were involved in a case that got some attention in November, where they represented 2 local bloggers who were blogging about local government in Maple Heights, outside Cleveland, I believe. And the mayor sued them for defamation, and they took up their case and eventually won. Kind of a classic sort of anti-SLAPP situation if we had had such a law in Ohio. So they're involved. And, just as a quick aside, going back to my old journalist editor days, when you think about the antipathy that a lot of, Tea Party groups and conservative groups have for the media, these are issues where we ought to be in common. The media and some of these Tea Party groups ought to be on the same page, because if there's one thing we share, journalists and Tea Party groups share, it's skepticism, bordering too often on cynicism about government. And a lot of Tea Party groups also perform a watchdog role. And again, here's a case where, that watchdog role is an important role under the First Amendment, under our form of government. Ohio Domestic Violence Network, there's documented instances where victims of domestic violence who have spoken out about what's happened to them, what they've been through, have been sued by their alleged abusers, basically in an effort to shut them up, to speak out. And so, these laws create very interesting groups in support. One group you're not seeing here, which some of the attorneys in the room may be wondering about, is the Ohio Association for Justice, the trial lawyers. They've been part of our conversations. They've opted out, being involved, and I can't speak for them. I'm hoping that at some point, if this starts moving, that they'll support it. I'm told in Texas, the trial lawyers came on board. They had bipartisan support in Texas, which is one of the model laws, and Governor Perez signed that into law in Texas a few years ago. Another group that, and this may be, and I'm speculating now, this may be part of the trial lawyers' concerns, one of the groups that has supported anti-SLAPP around the country is ALEC, the American Legislative Exchange Council, which is pretty well known as a group that helps conservative Republican legislators write bills around the country and drafts model legislation, and they've been pretty aggressive. ALEC has been very aggressive on the tort reform front, which of course is a difficult subject for the trial lawyers. But again, you know, I think the way we have crafted our law, and Jeff can talk more about this, is one that, you know, different parties can come to the table and support, because certainly no one's giving up their appeal rights and their right for there to be heard in court under anything that we're proposing. So that's a little bit about what we're trying to do. Again, I'm hoping we can get a bill introduced. I'm hoping that when we get it introduced, it'll have Republican and Democrat names on it, and you know, we'll see if that actually happens. So, I'm going to just talk very briefly about what's in our draft legislation, and then Jeff can talk in a little more detail about what that really means. Again, there's different quality of anti-SLAPP laws around the country. Texas and California, Nevada generally are seen as the best of breed, and a lot of what we have written, wordsmithed primarily by Jeffrey and Tom Heron, another attorney who's been involved in a lot of this litigation, with help from Lou Colombo and Mike Farrell, who are O&A general counsel up at Baker Hostetler, and a few others. You know, are based on Texas with a strong effort to conform it to Ohio law. One of Representative Cupp's questions, for example, is, does this conform with the Modern Courts Amendment? Is it too much legislative intrusion on the rights of the courts to set their standards for how cases are litigated? And, you know, we think we have good answers that it doesn't conflict with the Modern Courts Amendment. So hopefully the draft bill is consistent with that. One of the keys which I mentioned is defining protected communication and matters of public interest broadly. And you know, in the preamble, we're saying the Citizen Participation Act provides protections to persons who engage in certain specified protected communications and to protect the identity of persons who anonymously engage in online communications under certain circumstances. And I won't read the long list of how protected communication is defined, but I do want to just share with you what we are considering to be an issue of public interest, because this is important. It can't just be about, you know, the guy that speaks out at a public meeting or someone speaking out about what government's doing. And again, when you look at the lives we're living today, you know, and the growth of quasi-governmental, public-private organizations, and how much activity goes on that we engage in as consumers in our interactions with business. Look at what just happened at Wells Fargo Bank, to use a very simple recent example. We need the right to speak out about this stuff, not just about concerns we have about what government is doing. So issue of public interest in our draft bill means any issue of interest to the public, including an issue related to health and safety, environmental, economic, or community well-being, the government, a public official or public figure, goods, products, or services in the marketplace. So that's a pretty expansive definition, and I think it's critically important for that to be expansive. In essence, it's really pretty simple. The bill, as the laws in Texas and California do, create an expedited process for the courts. The defendant has to establish by a preponderance of evidence that the claim is based on protected speech. So again, we're not expanding the definition of protected speech, but it's protected speech. And then the plaintiff, in turn, to overcome the anti-SLAPP request, has to introduce clear, specific evidence that the case should continue. Neither side is giving up their rights to appeal. If the defendant wins on the anti-SLAPP motion, you get attorney fees. The plaintiff can go after attorney fees if they want to argue that it was frivolous conduct on the part of the defendant. And again, you still have your full appeal rights. And then we have added the provision in there, as I mentioned, an anonymous online communication. Jeff can talk in more detail, but in essence, what we're saying here is you have if someone is trying to out you, you're an anonymous commenter on Yelp about Bob's Chicken Shack, to use my earlier example, you have a right to be notified. The court has to approve even the request to seek your identity. You have a right to be notified. You have a right to contest it before the internet service provider or the chat board, whatever it is, would disclose your identity. And they also have a right to contest it. And I think that, again, is really important. And anonymous speech is a long, important free speech tradition in America, and we need to make sure it's protected in the digital age. So with that, I will shut up and hand it off to Jeff.
Hi, everyone. If you can't hear me, let me know. I'm not used to speaking into microphones. My experience with SLAPP suits is a little bit different than some of the other lawyers you'll hear from, because I don't have any institutional clients. I don't have the muscle of the dispatch behind me or public radio or anything like that. My clients are regular folks who got sued for speaking out. So I'm going to talk a little bit about some of my experiences representing these people, some of the hurdles that they've run into, and try to tie that back to some of the provisions in the law so you can see why we think we need it. Hopefully you would support it. But for the lawyers out there, if we don't get this bill passed, or if you encounter one of these before the bill is passed, you might have some idea of what to do about it. So I'm just going to try to hit some issues that are common to these cases. If anyone has any questions, feel free to interrupt me or stop me or chime in, my fellow panelists. And let's unpack these a little bit. Jocelyn talked a little bit about some of the types of plaintiffs, excuse me, that we see in these things. My experience is that there's one particular type of plaintiff that's very common, and that is the business that has been built up from nothing to a very large business by one person. Or so either the business is the plaintiff or that person is the plaintiff. People who start a company or take over a company and turn it from nothing into a multi-million-dollar, multi-billion-dollar company, they seem to have their sense of self-worth tied up in the business in a way that a lot of other people don't. And so it's very common to see plaintiffs like this. I think Robert Murray of Murray Energy would fit that description, though I don't know him personally or anything. But in my experience, that's a pretty common plaintiff profile. These plaintiffs also usually have been around the block before. This is usually not their first lawsuit. It's not their first threatened lawsuit. It's very possibly not even their first SLAPP suit. To give you one example, I had a client who lived in South Carolina. She bought something on eBay from a seller who turned out to be in Medina. She didn't know that at the time, but she bought something, he shipped it to her, and it arrived postage due. So she commented on eBay, left negative feedback, something like, item arrived, postage due without prior communication from seller beforehand. Absolutely true statement. Well, he sued her in Medina County Common Pleas Court for defamation. He sought an ex parte temporary restraining order and injunction to remove the speech. Once we got to represent her, we found several other defendants that he had sued that fit this profile. There's one from eastern Pennsylvania near Philadelphia. There was a lawsuit against someone from Michigan, a lawsuit from someone in Iowa. There was even a lawsuit against someone in Guam, all sued in the Medina County Common Pleas Court. So that's another thing that's very common to these. The venue of these cases is always someplace that's very convenient for the plaintiff and very inconvenient for the defendant. I can tell you that Amy Nichols of Greenville, South Carolina did not expect to be sued in Medina, Ohio for anything. She'd never been to Medina, Ohio. So it's very common to see them in out-of-the-way locales. Randy, you asked a question about where the Murray Energy lawsuits were filed. All three of them, the Patriots for Change, Chagrin Valley Times lawsuit, the Huffington Post lawsuit, and then there's a third lawsuit, excuse me, against some consumer advocacy groups out of Washington. All of them were filed in Belmont County, which is near Wheeling. The Patriots for Change protest that sparked the lawsuit happened in Pepper Pike up near Cleveland. Public Citizen is the consumer advocacy group. They're based in Washington. They have no business in Belmont County, and the Huffington Post people, I'm pretty sure none of them had ever been to Belmont County. But what do we know about Belmont County? It's in coal country, right? That's a good place for Murray Energy. So, if you find yourself in this situation as a lawyer representing one of these defendants, what do? Well, the first thing you do if you can is you try to remove it to federal court. The Huffington Post was successful at that. The others couldn't. The federal, you lawyers, you know your local bench better than I do, whether it's the state bench or the federal bench. But by and large, my experience is federal courts are more attuned to constitutional issues. They take them more seriously. Federal Rule 26 has a discovery planning conference requirement. You can't start serving discovery requests until you've had that conference, and so you can put off the expense associated with discovery for a while. Federal Rule 26, D, has an express proportionality requirement that we don't really have in Ohio. So by and large, if you can get into federal court, you're going to want to do that. You can try to dismiss for lack of personal jurisdiction. Again, if you've got a defendant from Illinois or South Carolina, as I've had, you think, what business do they have being hailed into court here in Ohio? That's a tough row to hoe. About 6 or 7 years ago, the Ohio Supreme Court essentially said in a case called Kaufman Racing versus, I think, Roberts, in a defamation case, you've caused an injury in Ohio, and so Ohio courts are going to have personal jurisdiction over those. But you can try. You're also going to want to try to transfer venue somewhere else. If the case is filed in Belmont County, the Chagrin Valley Times was able to get that moved to Cuyahoga County. Our statute addresses this in a slightly roundabout way. We can't, under the Modern Courts Amendment, prescribe venue for these cases, but we can give some protections kind of in the other direction for Ohio citizens who are sued in, say, Greenville, South Carolina. And so one of the provisions we've included here is a foreign SLAPP provision. If you're an Ohio defendant and you're sued in a SLAPP in another state, and you prevail in that, the statute would give you a private cause of action for damages and your attorney's fees in Ohio. So you can bring them back into your home court and get your attorney's fees back. Once you've established your venue, in state court, the plaintiff is going to start hammering you with very expensive, very invasive discovery. In the Chagrin Valley Times case, the Patriots for Change, who were doing the protest, was headed up by a couple named Jim and Lisa Ciocia, who John mentioned earlier. They had to turn over their computers, they had to turn over their phones. Murray Energy could literally rifle through their desk and turn their lives upside down to try to find any information that might be damaging. That's not only really invasive, it's really expensive. The Ciocias, as it happens, had insurance for this as part of their homeowner's policy. Most people aren't that lucky. It's not uncommon for companies like this. I had a case where the plaintiff literally spent $1 million to prosecute the case against my client. Literally spent $1 million over some nothing comments on a blog. So how does our statute address that? The mechanism in place here is when a SLAPP is filed against you, you've got 60 days to file what we call a special motion to strike. Special motion to strike does a couple of things. It immediately halts all discovery, unless there is some exceptional need that a plaintiff can demonstrate through an affidavit. For the lawyer, it's kind of like a Rule 56F motion, or in federal court, a 56D motion. It provides for an expedited briefing schedule. The plaintiff has a burden to show that's based on a protected communication, which is, as Dennis said, a communication that's already protected by the Ohio Constitution or the U.S. Constitution. We're not expanding the definition here. We're just saying the plaintiff needs to show that the Constitution covers this. If it does, then the defendant. The defendant shows it's a protected communication. If they do, the plaintiff then has their own burden to establish that there's clear and specific evidence showing this is not a protected communication, that it is defamatory. Then the court has to rule on that motion in an expedited fashion. I think the bill calls for 30 days. This is something that we borrowed from the commercial docket, expedited decisions for issues of great importance. Once that's decided, whoever wins, there's an immediate right of appeal, and discovery is stayed during the appeal. So, for example, when the Huffington Post was able to get the case into federal court and get it dismissed under Rule 12, I don't remember exactly. I don't think there was a 26F conference in that case. The whole case from start to finish lasted about 6 months. It was from November to April, as I recall. Over and done with in 6 months. The Ciocias, on the other hand, Chagrin Valley Times, as Dennis said, spent untold sums of money. That case lasted 2 years, from February 2013 to December 2014. And it was resolved under Rule 56. So they sat for depositions. Their computers were imaged and indexed and so on. Very expensive, very invasive. Our statute would stop all that, give you an immediate right of appeal, during which time no discovery can be done. That's really important. Another common theme in these cases is that you will find the plaintiffs almost universally, though I guess not always, almost universally seek a preliminary injunction. A preliminary injunction is a prejudgment order to do something or not do something. In this case, it would be a prejudgment order to remove the offending statement, delete the comment, unpublish the blog, delete the tweet, whatever it is. The U.S. Supreme Court has said this is absolutely unconstitutional. They've left the door open a little bit for maybe issues of national security or something, but to my knowledge, the Supreme Court has never upheld a prior restraint. And even without the Constitution, there's the common law rule that equity will not enjoin a libel. But plaintiffs will come in and try to seek ex parte temporary restraining orders and preliminary injunctions. We have not thought of, if anyone has any ideas on this, I'd love to hear them, a good way to guard against that in a statute, because it's governed by Rule 65 and we've got a modern courts problem. But our statute does create a substantive immunity from suit. That gives us the immediate right of appeal. That's going to get us past the Erie problem, so the statute's going to apply in federal court if you're lucky enough to get there. And with the stay of discovery, you're going to be able to push most of that off until another time. Dennis and Jocelyn both touched on the idea of anonymous internet speech, which is obviously a huge issue these days. The important thing to remember about this is that more often than not, the unmasking is the relief. They don't want to collect damages from, anonymous user 123. They want to know who anonymous user 123 is. Jocelyn alluded to the Steubenville case before. You guys might remember this. There was these two high school football players who were ultimately, I suppose, adjudicated delinquent for having raped another student. That case got a lot of press coverage when a blogger named Alexandria Goddard discovered social media statements by other people at the party and blogged about them. The community on the blog, 24 or so commenters, anonymously or pseudonymously weighed in and kind of trashed the football program. If any of you are from the Steubenville area, I'm not, but I grew up in Northeast Ohio, close enough to it that you sort of know football runs that town in a way that it doesn't in a lot of other areas. I know all of Ohio is pretty football crazed, but Steubenville kind of takes it to another level. In those situations, when anonymous 123 is trashing the football coach or the football players or whatever, simply unmasking them is the relief. Suddenly, this person is a social outcast in the town. So what we've done, about 7 states, I think, including just Kentucky, adopted it about 3 weeks ago, have adopted a test called the Dendrite test. Dendrite International versus Doe, or Doe versus Dendrite, was a New Jersey appellate division case from about 15 years ago now, I think, that set forth a 4-step process for unmasking an anonymous internet commenter. You have to give notice to the commenter. You have to specifically identify the statements. You have to make a prima facie showing that you have a claim. And then on top of that, there's still a balancing of the harm to the plaintiff against the harm that would befall the anonymous user if their First Amendment right to speak anonymously was taken away. We want to codify dendrite. We'd be the first state to do this. We would specify the type of notice you have to give you a substantive right to defend yourself even if you're not a party, give you a right to proceed anonymously, give you an immediate right of appeal if the order is to unmask you. We'd be the first state to do that. Yeah.
I'm sorry to interrupt.
Sure.
I was just wondering, what is the process of actually even finding out who an anonymous person is? Do you have to kind of, if it were like a comment on the dispatch, on dispatch.com, would you have to intrude on the dispatch to make them hand over information too? What's that process?
Sure. You sound exactly like you do on the radio.
Oh.
Yeah, so...
Why don't you repeat the question?
The question was, what's the process for unmasking an anonymous commenter? For example, if someone writes a comment on the dispatch website with an anonymous name, how do you go about getting that? The procedure is that you subpoena the host of the website for their registration records, IP records, anything they might have captured about that user. You take the IP address and you say, okay, well, that's associated with Comcast or whatever they're called now, and then you subpoena Comcast and say, tell me, what account is associated with this IP address on this date, and you kind of, follow the chain. It's hard to do. Sometimes it's very hard to do, but it can be done for someone who's persistent enough. And so our proposal is, the bill is, you absolutely cannot do it without a court order. You have to give notice. You have to give them adequate time to respond. And even then, you have to make a showing that what they said is actionable and more important than your right to remain anonymous. I'm really excited about this provision. It just actually, earlier this week on Monday or Tuesday, a judge up in Cuyahoga County, Judge Donnelly, I think, issued an order that essentially adopted dendrite, the dendrite analysis. We don't have any Court of Appeals decisions on it yet, but we want to get out ahead of it and get it codified.
Could you say the name again? Dendrite?
Dendrite, D-E-N-D-R-I-T-E, Dendrite International. I want to say it's like 2001 out of the New Jersey Appellate Division. I'm sure I have the citation somewhere if you'd like it.
You can come to the anonymous speech panel. We'll talk about it there too.
Oh, very good. The anonymous speech panel, we'll talk about it. I think 7 states have adopted it. I think 4, maybe, states have adopted a lesser standard known as Cahill out of Delaware from a few years later, which doesn't give you that balancing. And so really one of the things we're trying to do here is head off that potential adoption of a lesser standard and codify a good standard here.
Do you have the name of the case that was in Cuyahoga County?
It was Richard, I want to say Aldrich, U-L-D-R-I-C-K versus someone.
Okay. Thank you.
And I think I can probably even track down the order for you if I want. It's a short summary order, but that was the issue, and the commenter prevailed. So we can maybe talk about that later. John, I think I'm out of time, so I didn't have too much more I wanted to address anyway. Do we want to turn it over for questions? Or? Well, I don't really have a whole lot more without starting to ramble about some of my cases.
That's never stopped me in my teaching. My students will testify to that. So.
Yeah, I believe it. Well, are there more questions or any issues you want to address?
Let me jump in and ask one conceptual question for you. So I know that as a practical matter, it is very often the case that plaintiffs in SLAPP suits are intending to discourage or intimidate the target. Is that a legal requirement as well? In other words, if I'm the recipient of a SLAPP suit, do I have to prove that that is the intent of the plaintiff?
No, not under this bill. For a couple of reasons. One is that that sort of intent is difficult to prove. Second, constitutionally it doesn't matter. Remember, we're not talking about expanding substantive protections other than to the extent that we're creating immunity here. The Constitution already protects all this speech. So I don't think it would serve the purpose to add another layer of requirement on someone who's been put in this position. So no, that's not part of the proposal.
Okay.
Though it certainly is common.
Randy?
Well, I just wanted to point out that one of the dangers of SLAPP lawsuits is that it allows a litigious individual to establish a very chilling baseline to kind of serve as a a hammer over the head without ever filing a lawsuit, having written several stories involving Bob Murray and Murray Energy over the years. You refer to him as a cold key, but I guess lawyers send you your editor a letter. You refer to him as a frequent flyer when it comes to filing libel suits, another letter. You list his donations to the House Supreme Court when he appeals the Shriram-Thol's decision. Letter from the lawyer. I mean, there's all this going behind the scenes that never becomes public, but because they've established that baseline of litigation, they're hoping, I think, particularly with smaller publications, that they'll just give up reporting or not report facts even. So I think that is an underlying thing that perhaps a lot of people don't think about once that baseline's been established.
It's interesting. I'll jump in on that briefly. I wrote a couple of years ago now, it was in addition to my teaching and attorney stuff, I'm the press freedom correspondent for the Columbia Journalism Review, published at Columbia University. And I did a big feature piece on Robert Murray's litigation activities against journalists and other people engaged in public discussion.
There it is.
Oh, this is it. That's awesome. I'll sign it later. So I reached out to many people who had been targets of his threats or his litigation to ask them for interviews. And the vast majority of them did not want to speak to me out of the very same fear that you just mentioned, that they already had received half a dozen letters from him, his attorneys, in relation to the suits or threats that already had been made. And they said, I can't do this again. So I've seen that firsthand. And you know, it's interesting. So I've got all the way at the end of this piece, I've got 2 lines here. One of them, suffice it to say that whatever his motivation, Murray has a record of suing journalists or threatening to sue them, and the effects are evident. Even I thought twice before writing this article, and I am a First Amendment lawyer. So, you know, this is a real, live, chilling effect.
And that's certainly consistent with my experience. But again, from the point of a litigator, I'm not looking for a source for a story. I'm looking for a witness for my defense. I had a case not long ago where the plaintiff was so litigious that people would dodge my subpoenas. They certainly wouldn't talk to me on or off the record about the details of the claim. You know, generally speaking, I won't get into too many details here, but there was an allegedly libelous statement about maintenance at an apartment complex. So who do I want to talk to? I want to talk to the maintenance people. I want to talk to other tenants. None of them would talk. Absolutely not. You know, some of them went so far, when I did finally track them down, they flat out told me, I'm going to dodge any subpoena. I absolutely will not come and testify. That's the sort of effect that these sorts of things have. And I suspect, though I don't know, maybe Dennis knows this, and Randy, maybe you know this, I suspect that small papers like the Chagrin Valley Times get sued a lot more often than the Columbus Dispatch do. And I don't want to talk politics with anyone, but you know, we heard the other day that Donald Trump is threatening to sue the New York Times and the Palm Beach Post. Well, the New York Times has already shot back and said, bring it on. I haven't heard anything from the Palm Beach Post, which I suspect is a much smaller paper.
Well, there's two thoughts about that. One is the gap between the small and the big papers regarding resources to litigate is no longer that big. You know, nobody's got the resources to fight these battles the way they used to. And you know, you know, for anyone who's, you know, been an editor or been around libel and these types of cases, you most often get in trouble for little stories. It's not the big investigative project. I see Erin nodding her head as a media lawyer. You know, because those are carefully vetted. I mean, there are obviously exceptions, but if you're writing a big investigative story, your lawyer's probably read the story before it's even been published or broadcast. It's you know, you mixed up the filings in your agate on the federal, you know, who got charged in federal court this week, or it's the restaurant review. It's a small thing that just goes through your normal vetting process that maybe got by somebody, or in the case of Anti-SLAPP, it's you know, it's some offhand quote you put at the end of your city council story. You didn't even imagine would ever be controversial. Where some citizen stood up and said, I don't think they, you know, this developer's got kind of a sketchy track record. I don't want to see this apartment go up. And the next day you've got a cease and desist letter from his lawyer. So, you know, for both those reasons, I think this is important because, again, the resources to, you know, fight these cases are limited, and it creates a great incentive to settle even when you know you're right.
And I just want to add to your point that you're right. The underlying goal from these plaintiffs filing the SLAPP suits isn't really to achieve the favorable outcome in court. Usually they don't. It's to chill speech. And simply by filing the SLAPP suit, they're achieving their objective. They're essentially winning from their viewpoint. And I think that in our state, we really do need an anti-SLAPP bill to go through our General Assembly, because that is the one thing that we can really do to empower more individuals to feel comfortable speaking up on issues that they care about. There are probably a number of people out there that think twice before they engage in some sort of speech activity, before they write that blog, before they write that story, and that simply shouldn't be the case.
And the way we address that, give me 1 second, and then I'll let John take that. But the way we address that in the bill is that we do have a mandatory fee shift. A lot of these cases are frivolous, and if I were representing the plaintiffs, I would never sign the complaint because of my Rule 11 obligations. But, you know, Rule 11 sanctions are like unicorns. Like, you hear stories about them, but you know, nobody ever sees them. And there's a, you know, we have a frivolous conduct statute, 2351, but you know, I've had, for my Medina County case, I mean, I won a $19,000 frivolous conduct sanction. I haven't collected a penny of it. So one of the things we would do here is we provide a mandatory fee shift, not a discretionary fee shift, and the court can impose a discretionary penalty on top of that to try to deter future conduct.
Other questions? Yes.
You know, Jocelyn really raises a great point in that so much speech is stopped because of this fear of people with big money. At the 10 a.m. session, we heard conversation about big money can lie all at once. I mean, that is just an outrage. I'm just expressing my opinion. And as a journalist, we had a $1 billion lawsuit filed by Mr. Murray. That's all I'm going to say about that. It's not right.
My question was for Dennis, and I just want to make sure I got right what you had said. And you said that the new bill that you're proceeding with has more expansive definitions of the protected communication was one of the areas that was expanded. And then was it the community interest, meaning is the speech in the community interest?
There's two aspects where it's important to be broad. The bill needs to be broad in scope. And one is, how does it define what's an issue of public interest? And then I read that little laundry list. And then, how does it define protected communication? So it's the flip of that are states that have had very narrow definitions of what protected communication is, and then you're not covered in a lot of things that really should be covered. So those are kind of the two, and those two things kind of go hand in hand, is that those definitions need to be broadly stated.
And where are you in the legislative process? Do you have support for this? What's it looking like?
I have no doubt that Senator Yuko is interested in introducing the bill. You'd have to ask him, but I think there's a high probability he will introduce the bill. I don't know that he's decided if that will happen this fall. Again, as I said earlier, I can't imagine they would pass it this fall. I just don't see any way. Ludlow's shaking his head no to that, but it'll start the conversation. I think we'll get something introduced in the next General Assembly. And again, as I said, I really would like to see Republican names on that bill, and I think that's possible. But that's what we're working towards as we build our coalition. The draft bill we have, hats off to Jeff again and Tom Aaron, another attorney, for their hours of work on this. It's good. It's a good bill. It would be one of the best, if not the best, anti-SLAPP laws in the country, right up there with Texas and California, if we can get this done.
Dennis, can I add a couple of things that go back to the issue of what is something of public interest? So the history of SLAPPs go way, way back, and initially it was smaller in scope of what topic that someone speaking out about would fall into this category. So, like I said earlier, the oldest SLAPP suits really related to our right to petition the government, speaking out against some sort of government action. But over the decades, we've really expanded what we're talking about here. So an issue of public concern might be something related to the environment. Maybe it's a major company that wants to, frack in a certain area or put in a pipeline. Something talking about goods and services or products, right? So we've really tried to expand the definition of what would be an issue of public concern. And one of the nice things about being sort of late in the game on anti-SLAPP legislation is that we can actually review the best of the best that are out there to make sure that our bill is as good as it can be for our state.
And I'll just go even deeper on that. There are some states where you will find the protected activities defined so narrowly that it would only protect an individual's speech activities if the individual engaged in them, let's say in offering comments at a public hearing in connection with a matter of public business, like a bill, which obviously is extraordinarily narrow and would leave in the cold most people who engage in protected speech. So other questions? Yes.
So talking about the issue of what is an issue of public interest and dialing back to the example of a cyber SLAPP that was cited, that was a customer unhappy with the operation of a remodeling company. That, to me, does not look like an issue of public interest. It looks like we've got to a public citizen and what may be a small business or a bigger business at odds over their business relationship. And I do worry about making it more difficult for small businesses to protect their online reputations. I think that's a genuine concern. So how does that lawsuit fit into this bill?
I'll just add a few remarks. It seems like, okay, everyone wants to jump in. So under the current model legislation, this actually would be covered because there is a line item for goods, products, services in the marketplace. And Dietz Development was providing goods and services in the marketplace. They were actually a somewhat larger entity. It really wasn't the mom and pop shop. And Ms. Perez was really, all she was doing was leaving a review, a comment online. And I think, everyone in here has probably had a bad service from a company or maybe at a restaurant or something and wanted to go leave that negative review without fear of getting slapped with a defamation lawsuit seeking $750,000 in damages.
I was going to say, I think these are matters of public interest in terms of my interactions as a consumer with a business. It's information. I'm going to give you a personal example. If you search my name on Amazon, you'll find I'm an author, and you're welcome to buy my book. But when I published it a few years ago, I did what all authors do. I told my friends and my family to put positive reviews of Killing the Curse on Amazon. That's what everybody does. That's what restaurant owners do. That's what plumbers do. That's what everybody does. I have some negative reviews about my book. Most of them aren't, but and I have some positive reviews by people I do not know. The point being, if you're deciding whether to buy my book, that's part of the mix. And people know that some of that stuff's gamed in a positive side, but they also have a right to see the reviews by people that didn't like the book. Maybe it's not their cup of tea. And as they make decisions about consumers, how to spend, right, whether it's, $5 or $6 on Kindle or, $19.95 for the hard copy, or whether to hire that plumber because I have water pouring in my basement, which is a far more serious decision. I think that's a matter of public interest. So I would respectfully say that ought to be in there. And people can judge, what they want to believe and not believe about the stuff they read on Yelp or Amazon or Angie's List, whatever.
And the last thing I would say is that, as we've said before, by and large, the case law already includes that anyway. We're not expanding any protection here. We're defining it clearly and bringing it within the statute, but that's already protected speech.
Other questions? Brandon? No.
I know we've been talking about the negative side of SLAPP, but if you were to ask to play devil's advocate, is there a good example of how SLAPP is used effectively and why it's still even around? Like, is there a good example of how it can be used the right way?
There's certainly meritorious defamation claims. That, by definition, is not SLAPP, right? The strategic lawsuit against public participation, by definition, is not meritorious. This doesn't touch any meritorious claim. We're not crossing anything off the list that's currently permitted. We're just allowing for an expedited determination of whether or not it's already constitutionally protected.
And I think it's important, too, that just because someone files an anti-SLAPP motion, that doesn't end the lawsuit. I mean, it's just one hurdle to get over. And it looks like, even from this proposed legislation, that if you do have a legitimate lawsuit and you're bringing it and you overcome that hurdle, you've got a path to get your fees for that. So there's a balancing act there before someone decides to file an anti-SLAPP motion as well.
But there are people, I mean, in fairness to your question, Andy, I mean, there's certainly attorneys in Texas and California who would tell you that they feel that law goes too far. When people have what they would feel are legitimate defamation claims, that's too much of too high of a barrier. There are those that think that.
And I would say, most of my work in speech cases is defense, but I filed defamation claims. We've got a statute of limitations. I use it to investigate the claim in detail. I plead with specificity. I make sure I've got a good claim before I file it. Every lawyer should do that. A lot of lawyers don't. That's part of the problem.
All right, everybody, that's all the time we have. Please join me in thanking the panelists.